All right, we come to the mud wrestling portion of the program as we endeavor to understand what judicial review is, whether it's a good thing, a bad thing, and how Section 33 of the Charter impacts our understanding of judicial review and the role of the courts, and of course the relationship of the courts with the legislatures. We have an absolutely stellar panel of speakers in this section. And I am pleased to call up as our first speaker, Grégoire Webber, who's the Canada Research Chair in Public Law and Philosophy at Queen's University. He's also the Executive Director of the Supreme Court Advocacy Center. Grégoire.
Every reader of the Notwithstanding Clause first confronts the words that empower Parliament or the legislature of a province to expressly declare in legislation that an act or a provision shall operate notwithstanding the Charter's guarantees of fundamental freedoms, legal rights, and equality rights. For many readers, these words empower a legislature to legislate notwithstanding rights, and the reference to the operation of legislation or one of its provisions is passed over in silence. Yet for the reader who proceeds in reading the Notwithstanding Clause beyond its opening words, the question of the operation of legislation cannot long be ignored. For the clause next tells us that, for any act or provision in respect of which an express declaration is made, that act or provision shall have such operation as it would have, but for the provision of this Charter referred to in the declaration, shall have such operation as it would have, but for the provision of this Charter referred to in the declaration. The combination of the imperative shall have and the conditional as it would have makes for a complex reference to the operation of legislation. Yet this complex reference is decisive for understanding what the Notwithstanding Clause achieves, what it does, its legal effect. So what could it mean? That was the question that Robert Leckey and I explored together in a discussion 3 years ago this month. He had been in correspondence with Eric Mendelsohn about the legal meaning of the clause, and together, we set out to contribute to the public debate on the clause that was animated by Bill 21, an act respecting the laïcité of the state. The government of Quebec had introduced Bill 21 before the National Assembly the previous month, and the provisions of the bill included an express declaration on the operation of the would-be legislation. Much of the debate on the Notwithstanding Clause proceeded on certain assumptions about what the clause empowers the legislature to do, assumptions about its legal effect, assumptions about rights, and on judicial review. Robert, Eric, and I published the following month an essay in policy options in which we called or sought to expose what we called the received wisdom around the Notwithstanding Clause. That wisdom provides that the Notwithstanding Clause is an override provision. You've heard that term today already. That it empowers the legislature to override rights, to derogate from them, to suspend them, with the result that no court challenge may lie in judicial review against legislation for violating such overridden, derogated from, suspended rights and freedoms. We argued that there is no support in the text of the Notwithstanding Clause for such a received wisdom. Neither the word override nor many of its close cousins appear in the clause, and there is no reference to judicial review or other language that would affirm that legislation invoking the Notwithstanding Clause shall not be questioned or called to account in any court in Canada. Rather, the focus of both the express declaration and the legal effect of such a declaration is firmly on the operation of legislation. Noting that the French version of the clause employs the term effet, where the English version employs operation, we recalled that these same two terms would be found in the Constitution's Supremacy Clause, which denies to legislation that is inconsistent with the supreme law of Canada its force or effect, effet, or to employ the French nomenclature, renders inopérante, here a reference to the operation of legislation, provisions of any inconsistent legislation. The relationship between the Notwithstanding Clause And the supremacy clause is, we said, key to understanding what the legislature achieves when it makes an express declaration. We argued that the legal effect of the notwithstanding clause is to secure the operation of legislation, and that in so doing, the clause leaves open to challenge in court such legislation, and a court may determine whether such legislation violates rights and may declare that the law violates such rights. In our exchange of drafts before agreeing a final version of our policy options essay, we explored some possible differences on what more was open to a court after finding that a law was inconsistent with rights targeted in an express declaration. Robert, Eric, and I resolved to say less rather than more on this question, with a view to minimizing our joint agreement's complexity and controversy. Our focus was to draw the reader's attention to the received wisdom and to the operation of legislation, and to highlight how the clause was not best read as authorizing the override of rights or as eliminating the possibility of judicial review. In so doing, we had settled on one of three versions of what's been called an incompletely theorized agreement. Perhaps the best known version of such agreements is agreement on a particular outcome, as when judges on an appellate court agree on the result and on relatively low-level explanations for it, all without agreeing or needing to agree on fundamental principle. Few unanimous or majority opinions would be possible without such incompletely theorized agreements. A second version of an incompletely theorized agreement is one that we find in many constitutions. It's agreement on a general principle, all without agreeing on how that principle cashes out in particular cases. Grand declarations like freedom of expression, for example, can secure ready agreement, in part because the resolution of disputes about freedom of expression, disputes like blasphemy or hate speech or election advertising, censorship or publication bans, are all left to a later day. Robert, Eric, and I had settled on a third version of an incompletely theorized agreement, somewhere in between the first and the second, that is, agreement on a mid-level principle, all without agreeing on the grand theory that explains it, and all without needing to agree on how it cashes out in particular cases. When we pursued the further development of our argument in the policy options essay with a view to an academic article, we realized we could not put off disagreement on grand theory for much longer. And so we resolved to pursue our contributions to the public debate, this time by breaking the team of three into two teams. And so one way in which we sought to contribute to that public debate was in the fall 2021 issue of the University of Toronto Law Journal, in which I argued, alas, alone, that the notwithstanding clause left it open to a court to find legislation A, inconsistent with rights and freedoms, B, unconstitutional as a result, and C, of no force or effect, but C, not of no force or effect, so long as the express declaration remained in force, the express declaration that invokes the notwithstanding clause. A second way was published in the spring 2020 issue of the University of Toronto Law Journal, in which Robert and Eric argued that the notwithstanding clause A left it open to a court to find legislation invoking the clause inconsistent with rights and freedoms. So far, we're on the same page. But B, that legislation was not for that reason inconsistent with the Constitution. And C, here we are again on the same page, that the operation of legislation was therefore secured. In my presentation, I'd like to revisit with you the more general theory that I attempted to articulate, with a view to convincing you that maybe Eric and Robert should have joined me after all. That more general theory rests on two propositions. Here's the first, that there's a sequence from inconsistency to invalidity to inoperability that inheres in the relationship between inferior and superior law, between legislation and the supreme law of Canada. So if legislation is inconsistent with superior law, it is invalid, and because it is invalid, it is inoperable. Or to put it in a positive light, if legislation is consistent with the supreme law of Canada, it is valid, and if it is valid, it operates has force or effect. Second proposition, it is significant that the notwithstanding clause focuses on the operation of legislation. The notwithstanding clause targets the third in that series of 3 steps. The notwithstanding clause is silent on the consistency of legislation with the supreme law. It is silent on the validity of legislation. Its focus is on the operation of legislation. The idea, therefore, is the one that we had come to together, that the legal effect of the notwithstanding clause comes into play only after a finding by a court that there is inconsistency between legislation and part of the supreme law, the charter rights and freedoms that are subject to the notwithstanding clause. It was an idea that focused on the key expressions of the notwithstanding clause: shall operate and shall have such operation as it would have, in the French version, à effet et à l'effet qu'elle aurait, expressions that on the whole have not received much attention in the legal literature, and this despite the fact that these expressions are the engine of the notwithstanding clause. They, and only they, settle the legal effect of an express declaration by the legislature. But what is the operation of legislation? It's a term of art. And to explore the more general theory that accounts for it, or at least my understanding of that more general theory, we can turn to some historical examples, most significantly, you'll forgive me for this, a reference to imperial legislation, the Constitutional Laws Validity Act 1865. Why appeal to that now dated, very spent act of the imperial parliament? For 2 reasons. The first is that it relies on the analytical sequence just introduced. It provides that as between inferior colonial law and superior imperial law, the inferior colonial law that is repugnant to the superior colonial law is void, and because it is void, it is inoperable. The 1867 Act expresses an order, a sequence from the consistency or inconsistency of inferior to superior law, resulting in the validity or invalidity of that inferior law, and so too to the operation or lack of operation of that inferior law. To put it as a series of conditions, inferior law will be operative if it is valid, and it will be valid if it is consistent with legally superior law. But the second and perhaps more practical reason why that 1867 Act and its analytical sequence is of import is because the Supreme Court of Canada affirmed in an early case interpreting our Constitution's supremacy clause that our Constitution continued, quote, the constitutional jurisprudence developed under the Colonial Laws Validity Act, namely the jurisprudence of denying to the operation of legislation held to be repugnant to constitutionally inferior law. Now, that conclusion was not immediately straightforward for the court to come to. Why is that? Well, our supremacy clause does not employ the same key terms as did the 1867 Imperial Act. Our supremacy clause makes no reference to the words repugnancy or void or inoperative, as are found in the 1867 Act. Instead of the word repugnancy, our supremacy clause employs the term inconsistent, and instead of inoperative, our supremacy clause denies legislation's force and effect. As for the idea of void, it's nowhere to be found in our supremacy clause itself. Yet despite these differences, the Supreme Court affirmed that the words of no force or effect in the supremacy clause means that a law thus inconsistent with the Constitution has no force or effect because it is invalid. The analytical sequence from the Colonial Laws Validity Act, inconsistency, invalidity, inoperability, was carried forward into the Constitution's supremacy clause. A law is of no force or effect, inoperative, by reason of being invalid, void, on account of its inconsistency, repugnancy. One could have added that the Supreme Court would have strengthened its reasoning by noting that although the English version of the supremacy clause employs the expression no force or effect to replace what the Imperial Act had captured by the term inoperative, the French version of the supremacy clause makes no such substitution. It provides that laws that are inconsistent with the Constitution are inopérant, inoperable. So with these constitutional fundamentals in place, one can seek to understand why we were right, despite disagreeing on some fundamentals, to insist that the key to understanding the Notwithstanding Clause is to understand its relationship to the Supremacy Clause. In the analytical sequence from inconsistency to invalidity to inoperability, it is significant, I think, that our Notwithstanding Clause settles only the question of legislation's operation. The Notwithstanding Clause makes no mention of legislation's consistency with targeted rights and freedoms. It makes no mention of legislation's validity. The Notwithstanding Clause therefore leaves open for resolution the very question of legislation's consistency with the rights and freedoms targeted in an express declaration. And if it concludes that such legislation is inconsistent with those parts of the supreme law, it is open to a court to find that therefore the legislation is invalid. There's no discretion to interrupt the flow from inconsistency with the supreme law to the invalidity of law so inconsistent. The progression from consistency to validity inheres in the very relationship between inferior and superior law. Now you'll say, so too should therefore the second to the third step, namely the step from validity to operation. If a law is inconsistent and therefore invalid, if it is invalid, therefore it should be inoperable. And so it should be. But here the interruption in the flow from one to the other step is a result of the Constitution itself. It is the command of the Supremacy Clause to find inoperable, of no force or effect, any invalid legislation unless the Constitution says that legislation shall have such operation as it would have, but for the right and freedom targeted in an express declaration. Here, the interruption to the analytical sequence of the Supremacy Clause is provided by the Constitution itself, by the Notwithstanding Clause. But note that the interruption lasts only so long as an express declaration provided by the Notwithstanding Clause is in place. As soon as that express declaration expires or is revoked, the analytical sequence continues to its conclusion. Legislation held to be inconsistent with rights and freedoms, that is therefore invalid, would at that moment cease to have force or effect, all without the need to return to court to seek a new declaration. In the months intervening between our May 2020 policy options essay and our respective fall 2021 and spring 2022 journal articles, the Quebec Superior Court ruled in April 2021 on the constitutional challenge to Bill 21. A version of our policy options argument had been put before the Superior Court by counsel seeking a declaration that various provisions of that then law were inconsistent with targeted rights and freedoms. The court affirmed that it had this judicial discretion to make a declaration, reasoning that the wording of the Notwithstanding Clause n'exclurait pas une demande de jugement déclaratoire. Yet for reasons of judicial economy and a concern that a declaration of inconsistency would amount to ruling on the merits of the legislature's recourse to the clause, the court declined the invitation. In affirming the judicial discretion to declare whether legislation invoking the Notwithstanding Clause is consistent with the rights and freedoms, the Superior Court did not set out any general theory in support of its legal position. And in so doing, it saved itself many of the struggles that Robert, Eric, and I faced as we attempted to come up with such a general theory. But let me say this about at least my own struggles on the attempt to come up with that general theory. I owe a huge vote of thanks to Robert and Eric for the challenges and the instructions through our disagreements, and to the other panel members who will be joining us in this panel for their many challenges and instructions. And finally, a vote of thanks to Peter for the opportunity to relive all of these struggles again with you all today. Thank you.
I'm so embarrassed. I picked the wrong sport when I said mud wrestling. I meant gymnastics, of course, of the mental variety. Robert, please come up and have your way with this man's argument. Robert, of course, is the dean of my law school, so I'm particularly proud that he's here.
Thank you very much. It's wonderful to be here. Jamie's wearing a dress for the first time. I took my first flight, and this is my first in-person conference since before the pandemic. So I really should get out more, but I'm delighted that it's this that brought me out. And as Peter indicated, he's a BCL. He's an alumnus of our faculty, BCL LLB 1991, and I'm really proud to see your leadership in bringing people together to have such important conversations. And I'm thrilled to have followed Grégoire, and thank you very much for your generous account of things. And I want to signal the contributions, as Grégoire did, of my co-author, Eric Mendelsohn. So I find myself with kind of two papers from which I could speak this afternoon. The invitation clearly came on the strength of the paper co-written with Eric in the University of Toronto Law Journal, The Notwithstanding Clause, Legislatures, Courts, and the Electorate. But because Peter was covering my hotel cost, I had to write something new for the conference proceedings. And so I have a draft chapter called Legislative Choices in Using Section 33 and Judicial Scrutiny. And in my time, I plan to address 3 points that come out of the two texts. The first one is, why should we choose to interpret Section 33 as allowing courts to scrutinize a law protected by the Notwithstanding Clause? Why should we interpret 33 as allowing courts to hold a trial and to issue their conclusions? And I suggest that there are sound reasons consistent with constitutional interpretation for arriving at that interpretation. Second, accepting that courts can scrutinize a law protected by Section 33, how should they decide when to do so? And the short answer is the courts should follow the principles they use for other discretionary choices about when to hear cases. And they should, in particular, scrutinize a protected law when the result has the potential to inform the voting public about that law in a meaningful way. And third, time permitting, I would argue that in the new draft that we don't pay enough attention to the legislative design choices that go into each use of Section 33. How much of a law to shield, from which charter rights, and when to do it. And I suggest we should pay more attention to those design choices, among other reasons for clearer debates. And in particular, some of the theoretical justifications for Section 33 make sense based on some ways of using the device much more than others. And the discussions today have already confirmed my intuition that we owe greater attention to those design choices. But first, choosing how to interpret Section 33, or more specifically, how to interpret subsection 33(2), what we call the effects clause. And Grégoire quoted it earlier. It's 33(2) that states that once a legislature makes a declaration, the law in question has the effect it would have but for the charter right derogated from. And with all respect for other views, Section 33(2) is pretty laconic, and it doesn't answer a number of questions. I don't think it gives us any kind of debate-ending indication as to what the role of courts might be, aside from indicating strongly that a court shouldn't strike down a law protected by the Notwithstanding Clause. It really doesn't say anything, as Grégoire mentioned, about what the court's potential role is. And so when a constitutional text is indeterminate for a community of readers, what we need are reasoned choices among plausible interpretations. And so how do we decide? How do we make the normative choice as to how to interpret subsection 33(2)? In the UTLJ paper, Eric and I argue that conventional sources of constitutional interpretation align in favor of finding that courts do have a potential role. And to refer back to Dwight's discussion from this morning, Dwight Newman's, our endeavor is an exercise of constitutional interpretation, trying to fit Section 33 into the Charter and the Constitution. The Notwithstanding Clause's origins in compromise play no particular role for us. And so as the Supreme Court of Canada increasingly likes, I guess, we begin with the text. And so we read subsection 33(2) with the rest of the Notwithstanding Clause, in particular 33(3). And Jamie Cameron spoke about this morning. It's the sunset clause. And Jamie said that 33(3) shows us that democratic accountability is the bedrock of the Notwithstanding Clause and its legitimacy. And we agree with that. And so we see that 33(3) points to a crucial role for the electorate as a constitutional actor. It's up to the electorate to judge the legislature for using the Notwithstanding Clause. But we argue, and this again overlaps a little bit with Jamie's discussion before lunch, an informed electorate is better placed to discharge its function of holding the legislature democratically accountable. And you might kind of turn it around and say, would the electorate be better off if it knew less? Would the electorate be better off if left in the dark about the impact of a law protected by Section 33? And we would say no. So 33.3 itself provides a strong reason for thinking that the voters should know what's going on when the legislature uses the Notwithstanding clause to give effect to a law. Then in our paper, Eric and I turned to other constitutional sources for interpretation, the unwritten principles. And whatever Russell Brown has thought, it still seems reasonable to turn to them when interpreting constitutional text. And so there's a couple of unwritten principles that we see as particularly relevant. The principle of democracy, which in the secession reference, the Supreme Court interpreted in the Canadian context at least as being a rich notion that makes space for dissenting voices. That's not just about majority rule. Another principle, the protection of minorities. And Nathalie Desrosiers this morning stressed the vulnerable people who either cannot vote or are unlikely to be heard in the parliamentary processes. And so that principle as well, we think, militates in favor of having someone able to speak and to interpret what's going on when a law is protected from strike down by Section 33. So those principles and the reading of Section 33.3 for us lead to prima facie reasons for finding some role for the courts. But there's also more in our interpretation. We argue that such an interpretation, allowing Section 33.2 to be read as permitting courts from time to time to hold a trial when asked by plaintiffs and to declare when a protected law violates charter rights unjustifiably, we suggest that such an approach is also consistent with other pieces of the constitutional furniture. What are some of those other pieces? Well, one is parliamentary supremacy or sovereignty. And people often point to this principle as being the kind of driving idea underlying the Notwithstanding clause. So people often imagine, I think, that somehow precludes any role for the courts once Section 33 has been invoked, that it somehow silences the courts. But if you look hard at definitions of parliamentary sovereignty, whether it's in Hague, whether it's in Dicey, whether it's in Brun and Tremblay, you read it and it's all about the legislature deciding which laws are going to take effect. The real focus is on the legislation coming into force. But parliamentary sovereignty itself, the people defining it didn't say very much about, sparing the legislature from having people know the impact of its laws or having the courts talk about what they've done. And so as long as the courts don't strike down a law protected by Section 33, it's unclear to me how there's any conflict with parliamentary supremacy. Another principle relevant is federalism. And Dwight Newman has written about this and talked about it this morning, and as did Benoit Pelletier. So Section 33 is seen as fostering federalism. Provincial legislatures might use the Notwithstanding clause to resist the Charter's centralizing force. But again, there's no conflict here. If a provincial legislature strikes off on its own, departing from the national consensus on rights, why shouldn't the voters know that it's doing it? Why should there be a lack of information about that? Why shouldn't it be highly relevant to the voters to know that their elected lawmakers are interpreting rights differently than the courts have done? And so the idea that Section 33 could be deployed to protect distinct identities doesn't require, in my understanding, that happen in the dark without the electorate knowing the impact of the choices being made. And another part of the constitutional furniture is the role of the superior courts. So the courts have described themselves at times as the guardians of the Constitution or the constitutional interpreters. In the Gosselin Charter judgment from 2002, there's actually a striking paragraph where Chief Justice McLaughlin contemplates that courts may have a duty to declare a violation of even non-justiciable rights. The socioeconomic rights of the Quebec Charter, she says courts at times may have a duty to declare when legislation interferes with them. And there's been other cases, Mikisew more recently, Cotter, where the courts will declare that constitutional norms have been violated, even though they don't deny legal validity to a particular judicial or juridical act. It's possible that the Charter's remedies clause, Section 24.1, has something to contribute as well. It's not explicitly subject to Section 33. It refers to a remedy where rights are infringed. And Cotter tells us that a declaration that rights are infringed can itself be a remedy of sorts. So there's a number of reasons why, following a fairly conventional constitutional interpretation, we might conclude that the courts have some role to play. And so that invites us to revise the widespread assumption that Grégoire mentioned that there's really no review role for courts. So assuming courts have this potential residual role, turning to my second point, how should courts decide when to exercise it? And we suggest that the usual principles are a good starting point. You'd look for a plaintiff. Withstanding, you'd look for evidence, so we're not deciding charter matters in a vacuum. You would take care not to be deciding a moot legal issue, although there are even exceptions to the court's rule against deciding moot cases. But critically, we don't view it as a moot question whether a protected law is violating charter rights. We don't think it's a theoretical question like, what if the notwithstanding clause hadn't been used? No, we think the question is like, what is the impact today of that law? Bill 21 is having effect today as a result of the use of the notwithstanding clause. What impact is that having on people's fundamental rights and freedoms? That's a real question, not a theoretical one. But we think that courts would best use this power really where it would be valuable, where it would add new information. I don't think of it as courts guiding the legislature, telling it what to do. Dwight raised that concern and thought that wouldn't be helpful. I think the courts have a potential role in some circumstances to inform the electorate about what the elected lawmakers have done. And we recognize clearly that in some circumstances, there's not much value add from the judicial role. And there's been discussion before about preemptive versus reactive use of the notwithstanding clause. Where use of the notwithstanding clause follows judicial conclusions on the matter, there's not a lot of value add to going back to court. And we can think of the Saskatchewan schools case around religious funding. It seemed pretty clear what was going on when the legislature invoked Section 33. But in other cases, it's a lot less clear what's going on. It's a lot less clear what it is that the electorate would hold the legislator democratically accountable for. There can be a blanket derogation from all of Sections 2 and 7 to 15. The legislature might be protecting an entire statute or, heavens, an entire statute book. And in those circumstances, it's really much less clear what exactly is going on. In those circumstances, there's very little of what Lorraine Weinrib 30 years ago called specification about the use of Section 33. One can also imagine maybe the government would share its legal opinions from the government lawyers. And so the public could know what it was that the government was sort of shielding itself from via Section 33. But there's certainly circumstances where we don't have very much information. There's yet another example, which is one where the legislature denies that it's violating rights. And this, interestingly, we have in the Quebec case of Bill 21. And this is really interesting because some people imagine that once you reach for Section 33, you're conceding that you're violating rights. But Bill 21 actually states in its text that the laicity of the state is consistent with freedom of religion and freedom of conscience and the equality of all citizens. So far from conceding or kind of taking on the chin that it's departing from fundamental rights or even from the Supreme Court's interpretation of fundamental rights, Bill 21 has the legislature basically telling the electorate that it's not violating those rights, even though it invokes the notwithstanding clause. So on my reading, there's a clear potential for the court to apply conventional charter analysis and tell the electorate what the law really has done. So not all the time, but in some cases where plaintiffs ask, courts should hold a trial, assess a protected law, and declare their conclusion about its impact on charter rights. So I turn now to the third point, the choices that legislative drafters and legislatures may make when using Section 33. And here I draw on work by Speaker Hannah. And we've already talked here and there today about the choices that can be made. A legislature may protect a single clause or an entire statute, or as I said, the entire statute book in what Lorraine called the sort of maximum override that Quebec did in the 1980s. A legislature may derogate from one charter right or the whole set of ones, and it can do so after litigation or preemptively upstream of litigation. And these variables affect the potential value of a court's looking at a law in a way I just referred to. But they also affect the pertinence of varying justifications we have for Section 33. So some scholars, including Dwight Newman and others, look back helpfully at the views of the premiers involved in constitutional negotiations in the early 80s. So Alan Blakeney wanted to allow legislatures to look after rights that were not captured by the Charter, moral rights or socioeconomic rights. Peter Lougheed wanted legislatures to have a safety valve to disagree with courts. But these ideas work much better for some ways of using Section 33, some legislative design choices than others. They may work very well for a kind of targeted use. Again, the Saskatchewan religious schools funding case, protection of a single clause from the right to freedom of religion and equality, that can be plausibly viewed as disagreeing with the court's interpretation on charter rights. But those justifications, Lougheed, Blakeney, and so on, speak much less to the sweeping, unspecified invocation of Quebec's Bills 21 or 96 and Ontario's Bill 307 regarding elections reform. In a paper on the history of Section 33, University of Alberta constitutional scholar Eric Adams notes that all those involved in the early 1980s shared a commitment to charter rights. They had disagreements and concerns about how to protect them. That's really, honestly, not the vibe of the recent broad uses we've seen of Section 33. And Dick Moon this morning raised the question of whether conservative politicians had changed and so on. But the governmental rhetoric accompanying some of these more recent uses of Section 33 basically depicts fundamental rights and judicial proceedings as annoying impediments to the pursuit of a majoritarian agenda. Nathalie Desrosiers talked about disdain for fundamental rights. And so with all respect to Dwight Newman, these are not cases where legislatures are practicing rights protection or engaging in rights discourse. In the draft chapter for these proceedings, I suggest that many of us come to Section 33 discussions with an ideal or real case or two in mind. Jamie Cameron is clearly thinking about Bill 307. Dwight Newman's thinking about the Saskatchewan schools case. And I can admit that my own thinking has clearly been influenced over the past several years by Quebec's Bill 21. So you might want to think, what is your paradigmatic Section 33 case? Being clearer about our unstated assumptions and testing them against the empirical record of how our elected lawmakers are actually using the device should lead, I think, to better debates. And so to conclude, the Notwithstanding clause opens a possibility to legislatures to allow laws to have effect, notwithstanding their impact on charter rights. But more than is often reflected on, it imposes a constitutional role in the electorate. And it leaves open the possibility of a role for the courts to ensure that that electorate is well informed. Conventional resources of constitutional interpretation counsel in favor of reading subsection 33.2 as allowing the courts from time to time to play their familiar role of assessing a protected law's impact on charter rights in the light of precedent and evidence. And empirically, provincial legislatures seem to be using Section 33 in a broad way, more boldly. And even if occasionally it is sometimes to protect minorities, again, a possibility Dwight Newman reminded us of, it's often not. And so our discussions should really take account of the reality of those choices that are being made. Thank you.
That was absolutely fabulous. Thank you very much, Robert. And now I have the pleasure to call up Jeff Sigalet, all the way from beautiful Kelowna campus of the University of British Columbia.
Thank you, Peter. Yes, I'm one of the lone Westerners here to bring Western populism and all of its glory. I also grew up in Southern Alberta, so I got double representation, BC and Alberta. And today I'm going to make the case against the judicial review of laws that invoke Section 33. I make this argument with a lot of trepidation, partly because I'm responding to one of my mentors and teachers, Professor Grégoire Webber here. I feel a little bit like Luke Skywalker facing off against Darth Vader, or Aristotle criticizing Plato, or whatever analogy I want to use to pump Grégoire's tires or mine, you know. But seriously, I've learned a lot from him, and this criticism of his argument, and also Professor Leckey's argument, is kind of an homage to him, and I try to draw on his work as I criticize him. Sorry. Well, we'll see. You guys, we'll see who emerges from the mud wrestle, or whatever you want to call it. So my case against the judicial review of laws that invoke Section 33 is, on the one hand, legal. I put my lawyer hat on, even though I'm not a lawyer. And on the other hand, it's normative and political. And on that count, I'm putting my political science hat on and talking about some of the political dimensions of this question. Just to summarize my broad thinking, legally, I think that the clause cannot be reviewed by courts because questions about it are moot as a result of the meaning of the word notwithstanding, the legal meaning of the term, and because of the mood, the subjunctive mood in particular of the English clause of Section 33.2. So Leckey and Webber and Mendelsohn have all made this debate about the specific text of section 33.2, which I think is delightful because it's about the text. It's about the specific textual details. And so my legal argument is very much rooted in exactly what's going on there. And I invite, I'm very happy to be arguing on those grounds. The mood of the clause of section 33.2 makes a big difference because it doesn't invite courts to look at, it doesn't protect the operation of laws in the sense of protecting only the operation of laws and leaving open questions about its consistency. It tells courts and legal officials looking at the operation of the law to understand the laws as if they operate, but for, as they would in a world where the charter provisions they select don't exist, even though they do. It says but for, as they would but for, in an existential sense. And that leaves judgments about the consistency of laws with the charter very much open to people. The charter doesn't cease to exist, provisions don't cease to exist, but they have the legal operation, the legal fiction that they operate as if those sections didn't exist. So if we're getting into the nitty-gritty of the text, I think that those legal arguments count against the view that it's subject to review. Normatively, I argue that the clause should not be reviewed because it stands for the ability of legislatures to engage in substantive disagreements about rights and to disagree with courts in particular. And so by inviting the review of laws that invoke section 33, what we're doing is trying to check a check on an institution. We're inviting the courts to check the institution invoking part of the Constitution that's meant to check an aspect of judicial power. And I think that on that count, one of the positive things this notwithstanding clause stands for, this could potentially disrupt that. It also, though, I'm from the land of populism, but I don't think that the notwithstanding clause is always used in ways that protect rights. I think it can be used to ride roughshod over rights. And in those cases where it is used that way, in cases where it does directly run over rights in ways most or any reasonable observer will say the rights are violated in these circumstances, in those kinds of cases, it may actually be that having courts review those laws and declare them inconsistent with charter rights might actually provide a kind of political advertising and encourage uses of section 33 in those kinds of circumstances where we get those kinds of laws. And I have I'll explain a little more about my logic for thinking about that in terms of the strategic environment of what's actually going on in some of those cases where we see those kinds of invocations. But let me go through the legal argument first, and then we'll get to the political argument again, and then we'll open it up for more general mud wrestling or questioning. So the first legal argument I have is about the meaning of notwithstanding. The terms shall operate notwithstanding in section 33.1. The term notwithstanding doesn't mean that the law, that whatever it applies to is suspended. It doesn't express a conflict with whatever is invoked and targeted. But what it does is it invokes a relation of paramountcy. So in ordinary statutory interpretation, when you see a term notwithstanding, it doesn't mean, oh, that clause that has a notwithstanding term in it is just inconsistent with whatever it applies to. It could be perfectly consistent. But where it is inconsistent, to the extent that it's inconsistent, it expresses a paramountcy relationship. And so on this view, the Constitution is ensuring the paramount validity, ostensibly, of whatever law is invoking the part of the Constitution. The Constitution is declaring that this law is consistent with the Constitution, notwithstanding any inconsistencies you might find with this other part of the Charter. And in that sense, it renders any questions about the consistency of this law with this other law moot. Just on its own, that's without even looking to section 33.2, which is where the argument for the review of the clause comes from, right? In terms of what's going on in terms of the law protecting the operation in section 33.2. I have another thing to note about this aspect of section 33.1's, the technical meaning of notwithstanding, is that it means that the laws that invoke section 33 can have implications for rights, can express views about rights. Just invoking section 33 doesn't mean that the law invoking that is inconsistent with rights, which is it's something we should be really thankful to all of these gentlemen and Eric Mendelsohn for raising, is that they've really highlighted through their misguided parts of their, although our parts of the arguments are misguided, I think, the ultimate view that they have, one aspect of their ultimate view is the idea that laws that invoke Section 33 can be consistent with charter rights. And that allows us to say that the Section 33 can be used for the purposes that Lockheed and Blakeney talked about legally in terms of expressing views about rights that may be discordant with what judges have held about those rights in the past decisions, but nevertheless may be judged consistent by the charter with the charter by different observers, right? And this view, the technical meaning of notwithstanding, fits with that very nicely. It doesn't express a conflict with whatever section of the charter it applies to. It just expresses a relation to paramountcy in the case of a conflict, or in the case of an interpreter's view or reading of a conflict, right? So the second legal argument I have just tries to take the bull on the horns and wrestle with one of my teachers directly about the meaning of what is so special about Section 33.2 protecting the operation of laws. It protects when Section 33.2 makes its claim, it says, these laws shall have such operation as they would have but for the provision referred to in the declaration, right? And on Professor Webber's view, that protects only the operation of the law. It doesn't protect its consistency with the Constitution. It doesn't protect its consistency with the Charter. It doesn't protect, and it doesn't protect its validity either. Well, I agree very much that there's this distinction between the consistency of a law with the Constitution, its validity, and its operability. In federalism jurisprudence, we have laws that are consistent and valid under one enacted by a province, and laws that are consistent and valid that are enacted by the federal government. And one law can be, and the federal law is operative and paramount, and the provincial law is inoperative to the extent that there's a full conflict between a valid enactment under Section 91 and a valid enactment under Section 92, right? That relationship is completely right. It's like, I think that account of the relationship of consistency, validity, and operability is right. But where Professor Webber's argument goes wrong is that when Section 33.2 protects the operation of the law, it doesn't just protect the operation. The law has a subjunctive mood of saying that the law shall have the operation it would have, but for the charter provision in question. That doesn't invite us to say it's only the operation. It doesn't say it operates except for its inconsistency. It says it has the operation without consideration of the other provision. The other provision still is there. It doesn't edit or amend the other provision out of the charter provisions out of the charter. It just prevents us from assessing and understanding the constitutionality of this law in relationship to that provision. It's like ordering a vegetarian meal and saying, but pretend fish is, but I consider fish a vegetable. So if you bring me something off the menu that that involves fish, that's okay. And the waiter comes up and says, and brings you a plate with the fish on it and says, your vegetarian meal, sir. There's a subjunctive hypothetical going on there where you're pretending that this thing that is that you both know is not a vegetable is a vegetable here. Well, you may be, in this case, the courts, if they're going to be considering a substantive rights question about how the charter, a law invoking 33 relates to the charter, they may think it may look like a rights violation, it may smell like a rights violation, but so far as the charter's there, the invocation of 33 is there, they're not allowed to say what they think it is. The Constitution forbids them from exercising judgment about the constitutionality of this law in relationship to this other part of the Constitution. And it does that in a way, the beauty of the subjunctive is that it doesn't edit that other part of the Constitution out. It leaves it there such that the political branches and citizens can evaluate the consistency of the law with the charter for themselves. And so this subjunctive account of 33.2 is really indebted and reacted, and I only thought I would have discovered it in reaction to thinking about why they must be wrong. But I think it does sort of nicely explain how the technical legal meaning of 33.2 might explain how Section 33 prohibits substantive judicial review and leaves questions about the charter consistency of laws invoking Section 33 up to us, citizens, and up to our legislators, our representatives. Okay. I have lots more questions for my co-panelists about their arguments and how they relate, and I really would like to see more conflict between Webber and Leckey and them, and what I really want to know what the term operation is doing in Leckey's account of this and Mendelsohn's account of this, because I know it does in Webber. And I think on the indicative reading, on the reading that Section 33.2 just protects the operation of the law and doesn't protect its consistency or its constitutionality, then Webber's view does follow, I think. And it could be open to courts, although he's coy and doesn't say that they should do it, at least not in his UTLJ piece. and maybe we can get an answer from him. Maybe someone in the audience can demand that he answer the question of whether or not they should do it. But I would say that I know what terms of operation is doing in his account, but in my view, it's doing the opposite of what it's doing on his account. It's not protecting only the operation; it's protecting the operation in the world, in the counterfactual world. We must assume where that charter provision doesn't apply for assessing the constitutionality of this law. Okay, I promised a little to talk a little bit about the political science and political theory aspects of this. So, what are the normative implications here, and what are the normative reasons why, perhaps even on the argument that that either of these gentlemen's arguments are right, and legally it is open to courts to review these things, politically, what should we make of that? Well, I think on one strongly normative view, I'm also indebted to Professor Newman's work very much in this regard. I share the view with Professor Newman that the Notwithstanding clause stands for the ability, both historically and just in contemporary possibility, for legislatures to have a check on the potential for abuses of judicial power, right? It is a potential. It was inserted there because of fears about judicial activism under the charter, and in particular, it was insisted on by provinces worried about invasions of their jurisdiction by federally appointed courts under the charter. And insofar as that's true, the Section 33 stands for the ability of legislatures to make enactments that disagree with judicial decisions, or maybe even anticipate judicial decisions that may disagree with, about charter rights. And I think we can all think of Supreme Court decisions that we disagree with, where we think the courts get it wrong. They're interpreting the law wrong in this particular, and how rights relate to this particular hot button policy question. Well, insofar as we want legislative uses of Section 33 that invoke the Notwithstanding clause to protect an alternative vision of rights from whatever is elaborated by courts in that area. Insofar as we want that, it may be totally misguided to have courts then questioning those uses and acting as if their monopoly on constitutional interpretation extends even to the part of the Constitution and the use of the part of the Constitution that is meant to enable legislatures to question their judgment. That's on the normative. As far as we want those positive kinds of uses of Section 33, where there's at least a specific targeted view of what the rights question is here, that's maybe in disagreement with what a court has said. Insofar as that's a kind of use that we want to encourage, and it sounds like Professor Leckey and I agree that and Professor Newman all agree that the Saskatchewan case is one of those cases. It may be misguided then to have it go back to the trial court for another round of review, right? Why would we want the courts questioning that if the purpose of Section 33 is to give the legislature a chance to have its say? Like I said, though, I agree that there are cases where Section 33 is used in ways that violate rights, and that where few, if any, reasonable observers will say that there's a reasonable conception of rights at work and understanding of rights at work in the legislation in play. And in those kinds of cases, I think the political science should tell us, may indicate that having courts review those kinds of laws and those kinds of cases could actually serve as political advertising for legislatures that want to signal their disagreement with a rights consensus outside of a rights view, especially a rights view held outside of their province, let's say. So insofar as Francois Legault wants to use Section 33 in the Bill 21 legislation to signal that his support for laïcité and his refusal to bow to a federalist view, more Anglo-Saxon, Anglo-Canadian view of religious freedom, let's say, or minority rights, insofar as he's using Section 33 as a kind of way of not just enacting a view of rights that Quebecers have, maybe, but is also seeking to assert Quebec's provincial identity in that legislation. Insofar as that's true, having courts review that law further could serve as political advertising for him. He's saying, look at these federally appointed courts reviewing our laws and affirming their view of how our view of laïcité is unacceptable to les Anglos, you know, and insofar as that's the case, you know, it may having judicial review of these kinds of uses of Section 33 laws could have unintended consequences. It could be encouraging voters to vote for Francois Legault into another government so that he can continue and renew Bill 21. Or you could encourage the Liberals voting against him to promise to renew it insofar as it becomes a hot button election issue where the reenactment of the clause and protection of it comes as a signal of your commitment to Quebec's distinctive identity and its distinctive approach to religious freedom. And I say that as someone who's opposed to Bill 21. I think it's a violation of religious freedom. I think it's interesting it's continually characterized as a violation of minority rights. That seems like it's true that there's minority rights interests at stake here, but it's primarily and facially a matter of religious freedom and a violation of the idea that religious free exercise, the wearing of religious symbols by individuals, is part of religious freedom. And insofar as courts are going to review this and say that this is actually not even about religious freedom, it's about religious minority rights, to say something like that, having courts review these things this way can even potentially distort what rights disagreement is going on here. And I worry about that too. But anyways, I'm getting a little far afield from my overall points. My overall picture is that there are legal reasons for being skeptical about the legal possibility of the review of Section 33, and there are political reasons to question the wisdom of even having it, even if it is legally permissible. And that's my argument. And I look forward to answering more questions and maybe debating it.
Them's fighting words, Jeff. That was provocative and wonderful, and I know our question and answer period is going to be fruitful and stimulating. Okay, I have the pleasure now of inviting Xavier Foccroulle Ménard, who comes to us from, I'm not sure where you are right now, Xavier. Are you in Sherbrooke or in Quebec? Where are you?
I'm in Montreal.
Ah, in Montreal, okay.
Yeah.
So with another take on whether it's open to the courts to have their say, or whether their jurisdiction is ousted. I leave it by invocation of Section 33. I'll let you have the floor. Welcome.
Thank you very much. I wish I could do this in person, but I was in Toronto last month, and it was complicated for me to be here today. So, okay, and I also see that it says LLM candidate there, but I should have updated that. I graduated from U of T, and I'm now a practicing lawyer. So what we've heard many developing doctrinal approach to the legal effects of Section 33, and Matt. It was supposed to be Professor Maxime St-Hilaire that would present today, because in 2020, I believe, we published an article to answer the joint entry of Grégoire Webber, Robert Leckey, and Eric Mendelsohn. And since then, they have, the history has been provided to you. So they split and they further developed their doctrinal approach, but separately. And so what I'll do is I'll review these doctrinal approaches and then maybe provide some comments on them. So the two main approach that require particular attention right now. One approach is that of Grégoire Webber, who argues that the notwithstanding clause makes exception not to targeted rights or freedom and not to judicial review, but instead it makes exception to the remedy that would otherwise follow from a judicial finding that legislation is inconsistent with constitutional rights and freedom. And so under this view, it is possible to have judicial declarations of inconsistency between a protected legislation and the charter rights and freedom. And we've also heard Robert Leckey presenting his idea with Eric Mendelsohn, where he agrees with Webber that Section 33 precludes legislation from judicial remedy of striking down as set in Section 52. But for them, I think what is different is that the voting public plays a crucial role in assessing trade-offs about rights. And so they argue that the court's role is to, or sorry, the role of the courts is to support the constitutional role of the electorate. And to support the electorate in doing so, we have to declare, not we have to, but judges can declare the extent to which a given legislation is inconsistent with the rights and freedom guaranteed by the Charter. So in our view, these two propositions are a bit misguided. So to take Webber's argument, he really puts the emphasis on the word operation. But what I will try to argue is that while this is a textualist argument he brings forth, we should not overlook the part of the text which refers not to the rights themselves, but to the Charter provisions that guarantee them. And so when we look at the notion of provisions, we'll see that the economy of the Charter reveals that the notwithstanding clause applies first, not last, as was suggested. And so Leckey and Mendelsohn, on their part, seem to build on Webber's idea of operation, but to this they add the idea of the voting public. But from our perspective, the way they bring the idea of the voting public is a kind of subversion of the historical justification that the historical justification to suspend judicial declarations of Charter rights and freedom violations. And because the democratic purpose of Section 33 is, when we look at it, precisely what allows legislature to make final decisions on how to advance rights and freedom, and this is outside the specific determinations of the courts. So really there would be no place for judicial declaration of rights and freedom violations. Okay, so to the question, notwithstanding what, Professor Webber answers that the protected legislation applies notwithstanding remedy. And so that means that courts do have the power to declare the inconsistency of a protected legislation, and they also have, well, it follows from that there is invalidity, but it's also at the last stage of inoperability that would normally follow from such declaration that Section 33 applies, and then the inoperability is overridden. This is a very textual argument, and to do so, Professor Webber looks at the word operation in Section 33 and the words of no force and effect in Section 52. But the focus of the focus of Section 33 on legislation and operation shows that legislature can only secure the operation of the protected legislation, but they cannot cure the invalidity that follows from a judicial finding of inconsistency between such legislation and a right or freedom, which allows them to declare the inconsistency. And as I said, this view holds that the notwithstanding clause only takes effect at the end of the judicial reasoning on whether protected legislation is found inconsistent. So that implies a conceptual difficulty, because it means that there can exist invalid but operable legislation. And for Webber, nothing prevents the court from reviewing whether a protected legislation violates charter rights, and nothing prevents them from declaring the inconsistency. So I think he even says in his article that this would be a helpful remedy for informing legislatures of their obligations to respect rights and freedom. So that is a beginning of an answer to the question raised by Professor Sigalet. Now, the problem with this view is that, well, there are a few problems with this view. One conceptual, that is, which I pointed out, the idea of valid but operable legislation. But if we only argue on a textual basis, there's still a problem with this argument. And so I will offer an alternative textualist reading that I think is most respectful of the textual meaning of the notwithstanding clause. Because if we look at subsection 1 and subsection 2, and I know Webber and Leckey focus on Section 33.2, but I think Section 33.1 is also relevant because it says, Parliament or legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or provision thereof shall operate notwithstanding a provision included in Section 2 or Section 7 to 15 of this charter. And 33.2 adds to that. And this is where we see the legal effects. An act or provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would have but for the provision of this charter referred into the declaration. So what we notice here is the use of the term provision. And nowhere in the text of the notwithstanding clause do we see notions of rights or freedom themselves. So when Webber makes the argument suggesting to focus on Section 33.2, that the focus is on legislation and its operation, I would respectfully disagree. I think the focus of Section 33.2 is on the provision, and that is the most important term here, because this then poses an issue for the view advanced by Webber. And that is because if we say that it is the violation of a targeted rights or freedom by the protected legislation that begins the reasoning sequence with inconsistency, moving to invalidity and ending with inoperability, then we end up with this problem of provision. Because when we read the Section 1 and Section 52, what we see is that the Canadian Charter of Rights guarantees the rights and freedoms set out in it. And Section 52 says the Constitution of Canada is the supreme law, and any law that is inconsistent with the provisions of the Constitution. So a protected legislation cannot be inconsistent with targeted rights and freedom, because rights and freedom themselves are not mentioned. So what we have to do is read Section 33 and 52 together, but they must be read in harmony. A protected legislation can never be inconsistent with the provisions of the Charter, because it is precisely the legal effect of Section 33 as a provision of the Charter to remove any potential inconsistency. And we find, and another hint of that, or indication of that, is that Section 33 is found in the application part. So the structure of the Charter itself indicates that Section 33 pertains to the application or non-application of Charter provisions taken together as a whole. But the notwithstanding clause then does not appear at the end of the reasoning sequence from inconsistency to invalidity to inoperability. But Section 33 applies to, and Section 33 does not only apply to the latter step of the sequence. In fact, Section 33 applies at the stage of inconsistency itself between provisions of the Charter, and it cures any inconsistency even before Section 52 applies, and outright prevents any inconsistency from arising in the first place. Okay, so to summarize, the notwithstanding clause protects a legislation from ever being considered inconsistent with the provisions in Section 2 and 7 to 15 of the Charter, and thus prevents the supremacy clause from even applying. And since that means the courts don't have the power to issue declaration that rights or freedoms have been infringed, and because there is no inconsistency between the protected legislation and charter provisions, the constitutional validity of such legislation is maintained. So there are no rights violation, there can be no judicial review, and no remedies are applicable. There is nothing to declare. And so some support of our position have been given by Professor Sigalet, and we echo his view when he says that this Section 33.2 prevents courts from reviewing the consistency of laws with selected charter provision. But where we part ways with Sigalet is is that a full analysis and implication of his approach would confirm our initial position by Professor Maxime St-Hilaire and I, that Section 33 is an absolute, and it suspends rights and freedom, judicial review, and all remedies. That is in part because, as we've said, with Section 33, there is simply no inconsistency with rights. Professor Sigalet said we opened the door to an inconsistency with rights. Well, that is conceptually impossible, because the provision of the same act cannot be inconsistent one to another. They must be read in harmony. And so Section 52 does not even apply. Again, there is no charter right, there's no judicial review possible, no remedy is applicable. And so when all this is said, then there's nothing left really for courts to declare. Now, I'll have to verify with Maxime on how much he agrees with me, because there's also a just naturalist thesis that we can oppose to the interpretation of Professor Sigalet, because Sigalet challenged our view that Section 33 also suspends rights and freedom. But I would argue that it cannot be, just to clarify, it cannot be our claim that Section 33 suspends the rights themselves, because this would read into the notwithstanding clause much more power than it holds. My claim would be that Section 33 suspends the determinations of rights and freedom by courts. And so it transfers the jurisdiction to determine, specify, and delineate these rights and freedom to the legislature. So Section 33 is really a mechanism of transfer of power to determine rights and freedom from one branch, the judiciary, to another branch, the legislature. And so our understanding of Section 33, and this understanding of Section 33 should not be really surprising, because this has always been the historical one. It is to override a judicial interpretation of the Charter. There's been many debates on this, and we've seen Goldsworthy weigh in and Jeremy Waldron weigh in, and in response to all these arguments, Peter Hogg, Bushell, and Wright, they've answered, I think it was in 2009, and they said that the public will realize that the legislature is in fact overriding a judicial interpretation of a particular right or freedom rather than the actual right or freedom itself. So here the idea is that the view that Section 33 suspends judicial review is a corollary, a formal necessity of the view that it suspends the determination of the charter rights and freedom by the judiciary. The notwithstanding clause suspends judicial review because it also suspends the right and freedom as guaranteed by the provision of the charter for the purposes of the courts. So since the rights and freedom are guaranteed by the provision of the charter, it is not an abuse of language to conclude that Section 33 suspends rights and freedom as guaranteed by the suspended provision. But of course, it would be an error to say that Section 33 suspends the right themselves. Legislatures are entirely free and even encouraged to consider rights and freedom in making a determination on such rights or freedom that differs from that of the courts. So that means Section 33, and then I will repeat myself, but Section 33 is an absolute. It suspends rights and freedom, judicial review, and all remedies. So to move on to Leckey's and Mendelsohn's argument, Leckey and Mendelsohn agree with Professor Webber that Section 33 precludes the judicial remedy of striking down. For them, Section 33 prevents a breach of charter rights by the protected legislation from amounting to inconsistency with the Constitution of Canada for the purposes of the Supremacy Clause. And they call this the necessary effect of the notwithstanding clause. But beyond these necessary effects of preventing inconsistency, Leckey and Mendelsohn argue that the notwithstanding clause leaves open a role for courts in scrutinizing protected laws. Section 33 would then allow and even invite judicial declaration about charter rights and freedom violations. So Leckey and Mendelsohn claim that nothing in relation with the notwithstanding clause suggests that its effects are to prevent judicial scrutiny of protected law, and not even are these permissible, they are also encouraged. If we focus on subsection 33.3, which makes space for the voter to assess the legislature's use of the notwithstanding clause, judicial declarations serve the democratic purpose and partly redress the knowledge gaps between courts, legislatures, and the electorate on such use. So the interpretive task for Leckey and Mendelsohn requires to integrate Section 33 into the Constitution by focusing on its components, that is, Section 33.3 and subsection 33.4 and subsection 33.5, and on focusing on the foundational principles of the Constitution, and in particular, the idea of democracy and protection of minorities. And they point out the expiry idea in subsection 33.3 and 33.4 to indicate an important role for the electorate acting through the democratic purpose. And so for those unfamiliar, 33.3 and 33.4 say that a declaration made under Section 33 shall cease to have effect 5 years after it comes into force, and this declaration may be reenacted. And so the idea is that the orthodox position, at least, was always that these subsection place the voter in a situation where they act democratically as the ultimate check on the use of the notwithstanding clause. But Professor Webber and Mendelsohn say that this also highlights that the legitimacy of the use of the notwithstanding clause derives from democratic support, and this creates the idea of democratic responsibility. And for the whole framework the whole framework depends on the voting public having access to knowledge about the consequences of a legislature's use of the notwithstanding clause. Okay, well, the answer to that argument, which is very interesting, is that, well, there's already the first problem highlighted, which is that courts have no inconsistency to declare. There's nothing to declare because there's no inconsistency between provisions. It cannot happen conceptually, and so this never amounts to rights violation. It cannot happen. And so there's already that problem. But if you want to go further and complete the analysis, we can look at Section 33 and 33.3 and 33.4 in light of the historical purpose of the notwithstanding clause. And so the primary purpose for including Section 33 was preventing and remedying the undemocratic mischief of judicial misinterpretation of charter rights. And so the idea was that the Section 33 ensures that charter rights remain subject to a final political judgment, and even and Blakeney also, one of the founding fathers of this idea said that Section 33 serves the legislature also to protect unenumerated rights and freedom that might be threatened by judicial decision. So they do incorporate a deep commitment to the value of democracy, but this value is already reflected in the text of Section 33. And so I would argue that Leckey and Mendelsohn are correct to value democracy, but the historical purpose shows that the very idea that democracy is important is there in the text, in that Section 33.2 prohibits judicial review, meaning that courts are barred from reviewing and contradicting charter rights and freedom determinations of the legislature. And I think this was long, so I'm going to leave it at that.
Well, we have a lot to think about and to consider, and I'm sure that there are questions. I don't see hands up. Svi, you want to come up to the microphone? I want the panelists to have an opportunity on their own to kind of respond to what they've already heard, but we can start off with your question.
Okay, so I have a few questions, comments. First of all, to Grégoire. How does it feel to, on the one hand, to not support judicial activism, but then to essentially want the court to do something very activist? I mean, I've always pegged you as a passive virtues type of guy, right? And then now you come and you say, that's the first question. Oh, because you talked about the interaction between the three of you, so I thought it's a legitimate question. Now, the second question is to Robert and Grégoire. Suppose Section 33 did not include the sunset mechanism. I mean, to what extent? Because my hunch, I agree with Grégoire, but I agree with him only because I think 5 years is really a very short period of time judicially. And so there's always a point in making the declaration such that, in making a declaration of inconsistency with the Constitution, such that in 5 years it would take force. But I'm curious, had it not have that provision, what would your view have been? And the last question, I forgot. No, I had the third one. Yes. So more than 20 years ago, there was an article, I think both of you mentioned it in your footnotes, but by Donna Greshner and Ken Norman. And they have an interesting view. Their view back then, the topic that Jamie is now reviving, which is judicial review on use of the Notwithstanding clause, was big. That was the discussion. And they say in the discussion between whether there could or could not be a substantive review on the Notwithstanding clause, we have an intermediate view whereby there is a requirement of a court saying that the legislation is indeed inconsistent, so that it is indeed notwithstanding. Now, so this is just a comment, maybe an obvious comment, that if we accept, and I imagine Kristen and Freddie is going to propose that tomorrow, that the notwithstanding clause should only be used remedially, then that would settle the differences between all of you, correct? In the sense that then we would know. I want to make sure that in that case you will all agree. That's it. Thank you.
Thank you, Svi. Let me try to take the questions in order. The first was about the role of the courts. And my response there is that I'm offering my best reading of what the law requires. So it is the lawyer's task to interpret the law as it is and not as it ought to be. So whether I agree with the conclusion I come to or welcome its consequences or not, wholly decides the point insofar as I'm reading the text as best as my lawyerly skills allow me to read it. Your second question turned on whether there would be any point in going to court to securing such a declaration if the express declaration of the notwithstanding clause did not expire after 5 years. And on my argument, after 5 years, unless the declaration is renewed, well, the consequences of a judicial declaration of inconsistency kick in, and such that the law is of no force or effect once the express declaration expires. And your query is, in the counterfactual world, according to which there is no 5-year limit. I think the counterfactual world is the Commonwealth world, and we've seen references to the Commonwealth already. Let me just give you the example of the United Kingdom. The United Kingdom empowers a court to declare an inconsistency between European Convention rights that are recognized in the UK Human Rights Act, but makes it very clear that the operation of legislation survives any such declaration of inconsistency. The expectation when the Human Rights Act of the United Kingdom was enacted was that the legislature would respond to such judicial declarations of inconsistency, even though it was under no legal obligation to do so, and on the whole it has. Now, I think the proposition holds even if the UK legislature had not responded as it has, namely for the public education aspect of understanding whether the legislature has acted contrary to rights or not, in the court's view. And I accept the views of others that the court's view is not the only view on the consistency of laws with rights. Your final question is now testing my memory. Can you give me a prompt? Oh yes, the Greshner. So this turns on Nathalie's earlier discussion about prospective, retrospective. Let me just highlight two legal points, staying within the lane of the lawyer. The first is, I think if we're going to get to a legal position where it can only be used remedially, that is after the court has already made a finding, it would run something like the Greshner view, namely that you need a finding of inconsistency because without inconsistency, the operation of legislation is already secured, so there's no need for the notwithstanding clause. The other query, though, is it's not clear to me how, as a matter of law, this would quite work. So let me just give one very quick example. Prisoner voting. So we have two cases from the Supreme Court. They both challenge federal legislation. The answer, I think, after the second one especially, is very clear. I cannot imagine a scenario without the notwithstanding clause where inmates would be prohibited the right to vote. If a province now decides to try to enact the equivalent of the struck down federal provision, would we call that remedial? Would it be responding to or would the province have to go through the motions of enacting the text, waiting it for it to be challenged, struck down, all the appeals exhausted, and then go through the entire process again? So I just raised that question.
I'll be very brief. But I mean, the question was, what if 33.3 weren't there? What if the 5-year thing weren't there? And of course, the derogation clauses in Quebec Charter and in the Canadian Bill of Rights don't have those 5-year things. So I think if those weren't there, you need to look carefully. I think in our constitutional interpretive context, protection of minorities would still be there. The democratic principle would still be there. So you could think hard about it. But for us, 33.3 was really significant because the drafters in the early 80s knew about those other derogation clauses and they chose to add the sunset clause. So for us, there's like yellow highlighting already on the page that has to be taken very seriously in interpreting Section 33. Now, your question to Grégoire about the sort of radical nature of the kind of stuff we're exploring, like I honestly think we need to sort of switch the onus and say, like, once 33 is in the charter, I think the radical position, frankly, is what Xavier was talking to, that it should be taken as sort of absolute, that sort of creates a black hole in the middle of the charter, because the language itself doesn't say that. So once it's in the charter, all our traditional approaches of constitutional interpretation say you read the stuff as a whole, you bring in the principles, you try to interpret one part of the Constitution so it doesn't do damage to the others. So once you say we have the constitutional role of the courts, once you say we have all these principles, I think you say, like, something that looks at first blush like an exception should be kind of, you try to fit it into the other pieces. But the idea that the language in 33.2, and it's great to have the thing in the program, at least in English, because so many discussions don't depart from the text. That's not the language you would use if you were trying to say we're going to sort of create this black hole in which courts will lose their normal role and absolute power will be confided to the legislatures. It's simply not the language you'd use. And so I think what's interesting to think about is, like, why do we accept for so long people's sort of starting points and assumptions untethered to the constitutional text, that that's what 33 is all about?
I'm hoping that you can help me with this. I'm asking you these questions, or this question, as a barrister who may be approached by, say, a community group or an advocacy group, interested in following up on your ideas. And they have somebody who is prepared to be the nominal plaintiff, who is actually prejudiced by the law as it stands with Section 33 in it, which says it's going to operate notwithstanding Section 15. And the law is having a profound discriminatory effect on that person. And so I'm trying to tell that person and the advocacy group what they would get if they went with this theory. And I had this trouble when I read some of these papers, and I'm afraid I still have it now, even after listening to you talk, because it seems to me that what I would have to tell them is that we might and in the best case, get a declaration from a court that there is a conflict here with a charter right. But that charter right is one that doesn't apply anyway. So you have a sort of an abstract statement that may come into effect 2 or 3 years down the line if nobody appeals it. And so you also say that the litigation getting to the first stage of a Supreme Court or a Superior Court ruling might take 2 years, and there would only be 3 years left on the 5 years. And the litigation is going to cost a certain amount of money. And if you're not successful, you're going to have to pay the government's cost. And so what I'm wondering is whether I should recommend this course of action to that person in the support group, or should I tell them, let's just see if we can find some other section of the charter that the law is contravening. So, like, tell me what are the advantages to the client and to the group seeking change that reside in your proposal, if you would.
I mean, if you had a right that's not amenable to Section 33, by all means, I think you'd want to go with that. So, like, you know, you and Jamie could sit down and talk about Section 3, for example, and maybe, you know, that would be great. But the kind of declarations that Eric and I had in mind, not ones you'd necessarily use all the time, but to give a very concrete example, and I acknowledge that this has kind of shaped our thinking, there's polling in Quebec that suggests that if the public actually knew that Bill 21 discriminates unjustifiably, that would affect public support for the law. And so we're in a context where the government actually denies that it's discrimination, and the government denies that it limits freedom of religion, because the government sort of says, look, it applies to everybody, so it can't be discriminatory. And the kind of stuff you learn in first year about differential impact and indirect discrimination doesn't seem to have made it to the lawyers working for the current provincial government of Quebec. And so I think it would change the conversation in some contexts to have an independent expert decision maker declare the sort of hardship that individual people like your client are experiencing. Now, if you feel if it's in Ontario and everybody kind of knows this and it still isn't affecting the discussions, it might not be worth the candle. But I think there are at least some contexts where having the judicial outcome, which people continue to respect and place a lot of value on, could drastically change the discussion as to whether, for example, the 5-year override should be renewed or whether the thing should be repealed. But you'd clearly have to weigh things before you went ahead. Like this wouldn't be my preferred recourse for your client.
So I'm just to follow up. I take your point about, if there are other provisions of the charter, you wouldn't necessarily be having to contemplate going down this road. I accept that we're in a situation where there aren't any other provisions of the charter. But then let me go on to ask you, if you embark on this course of action, do you not have to be pretty sure that your case is going to be successful? Because the publicity value of doing this litigation works best when the court agrees with you that the law is contrary to the charter. What if the court is like the current majority of the Supreme Court and says, well, there's nothing in the text here that says anything about this, and so you lose, go away and pay the costs? Is that too much of a risk to run, with the judges being the way they are these days?
Always the risk.
So how do you deal with the risk?
With that risk is there in every charter case.
Yes, I know, but
Worse off if you lose.
I know, but usually in other charter cases besides this one, you have something to offer in the sense that if you go to court and there's a declaration, just a simple declaration that the law is contrary to the charter, usually if the government doesn't appeal, they will sit down with you and actually change the law. And that's why we have those declarations that are delayed in coming into effect, specifically to give the government the chance to change the law. And that's a pretty well established feature of constitutional litigation. So if you tell your client, well, we're not going to get that, because if we win, they could just turn around and repass the law with Section 33 in it. So it's pretty slim chance, I think, that your strategy would produce the result that you want, namely public sort of realization that they're being sold a bill of goods and this is a terrible law.
I have very little to add to what Robert said, except to maybe refer to what barristers in the United Kingdom, New Zealand, and in 3 or 4 Australian states tell their clients, because all of those jurisdictions operate in a world where a declaration of inconsistency does not result in any loss of operation to the affected legislation. And what is more, there's no expiry to when the operation of legislation will cease to be protected. So it's baked into their bills of rights what the notwithstanding law clause allows our legislatures to do. And yet, my quick survey of the case law in the United Kingdom, New Zealand, and various Australian states would suggest there's no shortage of barristers or clients willing to take their chances before those courts.
Well, that's the ruling option.
Thank you for your presentation. So I have 2 short comments and then a question. First comment, the idea that the court should render judgment on the inconsistency in order to inform the voters and therefore potentially influence the result of next election. I think it would really lead to a very political role for the court. So that's a first comment. Then second comment, I feel like this kind of idea, it's about bypassing partly the notwithstanding clause. And every time I hear ideas about how to bypass the notwithstanding clause partly or completely, it leads me to reflect about the alternative to the notwithstanding clause. If you look at the United States of America, they don't have a notwithstanding clause, but they have disagreement between the politician and the court. And the alternative to that notwithstanding clause seems to be court packing and court bashing. So my question is, don't you think that if the court renders judgment on inconsistency in order to inform voter, will that lead to more court bashing? Because of course, in the case of Quebec, there's no power to appoint judges, so there's no court packing. It would be court bashing. And when I think about court bashing, I mean, of course, by politicians, as we see in the United States, but also by citizens. Because in an era of social media, I think that citizens who don't agree with judges, they will go on social media and they will say very frankly what they think. And maybe you remember that what happened at the very end of 2019 with Justice Duval-Essler of the Court of Appeal. She was basically about to render a judgment on whether or not to suspend Bill 21 before the judgment, the trial on at the Superior Court level. And she was perceived for different reasons as being not neutral when it comes to Bill 21. And it was a very big mess mediatically, and there was many complaints at the Conseil canadien de la magistrature. And on the social media, people were very critical towards her. So I think that there's a risk of court bashing here, and I would like to hear you on that subject. Thanks.
So I'll take that question. So you say there's court packing and court bashing as the options for responding to judicial politically unpopular or controversial judicial decisions. Well, I would also add in the United States, there's not just court backing, there's also jurisdiction stripping. It's open under Article 3 for Congress to strip the jurisdiction of the Supreme Court of certain kinds of questions. There are bills introduced that do that, and political scientists measure the extent to which that they're introduced in the wake of different kinds of Supreme Court decisions. They're not passed very often, but that's another interesting thing to note. And another thing I'd add is in addition to court bashing is often goes with the politicization of appointments processes, right? The more that courts inject themselves into this kind of a political conversation more directly political kind of conversation, where they're trying to change the discourse directly about a rights question that's in the legislature's constitutional ballpark because it's used Section 33 or talked about using it, the more that you politicize the judiciary. I think you're right about that. And court bashing will come with calls to politically influence the judiciary. I think that something really amusing about Canadian scholarship for me about this is that the Canadian court and the Canadian courts as an apex court is very young comparatively. The charter is extraordinarily young compared to the American Bill of Rights, let's say. And there's this idea that like, oh, the court will continue to be this much less politicized thing under Canadian history because it just so happened to go a certain way for the first couple of years. Well, this is not going to be the case under our charter eventually. The politics will catch up with the court. Our appointments process eventually will become more politicized. And I bet you a mortgage on a house in Kelowna that will happen. And so I really do see this, like the potential to review uses of 33 has the promise of accelerating that. And what's interesting, I mean, so just from a pure political science perspective, what's kind of fascinating about 33 is that unlike those other court curbing measures, it doesn't directly affect judicial independence, actually, right? It lets the legislature take on a rights question and take over jurisdiction for it, right? But without having to change the nature of the court, the size of the court. And so, I mean, that is an interesting aspect of its, and in a way, that's a great virtue of it, as opposed to those other instruments which further politicize the judiciary and prevent it from staying and prevent it from serving as justification of having lawyers decide these things, right? Why should lawyers decide questions about certain kinds of highly politicized moral things rather than my grandma or zookeepers? You know, I really think that more law schools should teach that question and say, why do you think lawyers have a specialization in this? Is it because you're little philosopher kings and you know more about the right to life and where it starts and where it should begin and how it relates to these kinds of highly politicized contexts? Does the charter really legally spell out some of these questions? No, you're lawyers. You're learning about how to apply rules and think about them in these complex circumstances. And you are trained to do that. But you don't have some special training in moral philosophy. Even moral philosophers don't have a special right to settle some of these kinds of questions. Regular citizens get to disagree about them, right? And the more we have courts just sort of explicitly engaging in this kind of moral reasoning, not even tied to a constitutional effect, the more we're going to accelerate the ability of the political process to tackle them and say, legislative actors saying, aha, you're doing politics, so why do you have independence, you know? Anyway, that's my rant, sorry.
Do you still have time? Well, actually, I wanted to go to the fact questions that Grégoire asked, which is a provincial government wanting to remove the right to vote to inmates or to... Now, it's a weird questions because it's Section 3, so therefore, you know, it may not be. But let's assume, I think the questions was more about, does it have to wait? Does it have to pass a statute that, you know, let's use prohibiting protest for anti-vaxxers, you know. Does it have to wait for it to be challenged, for it to go all the way, and then at the end, you know, to say, well, we disagree with the way in which the court interpret Section 1 in this case, and therefore we use the notwithstanding clause. So to me, I was struck by the fact that nobody talked really of the role of Section 1 in the way it has been interpreted up to now. It gives quite a bit of leeway to government to explain, to change, to just, you know, maybe it's just because I was with the Cara at the CCLA, but we felt we lost often, you know, and that the government won often because they have the information, they have the way in which they can structure the information. So the ability then to say, and the court changes its mind on it. So I thought maybe freedom of association and collective bargaining might be a better examples because it's in Section 2. But why not was my question. Why not allow for a deliberative process to go on, for people to be engaged in it, and then eventually as a remedial to say, well, finally, we've had 10 years of discussing this. And so I don't see what we lose in facilitating, I don't believe that lawyers have a monopoly on the truth, and I don't believe that they are expert in conflict resolution in a way. That's what, and in the training that is given to managing deliberations and arguments and so on. And people disagree, and we continue over. So if we're looking at the grand scheme of things, why would you not want to say that? And to my final question is, why do we want a hole in the charter? What's the idea of trying to strip it and create that where you could? Why any government, after listening to you, would not use the Section 33 all the time? So yeah. Well, that's so. So are we then, amending the Constitution without doing so? So I think that's kind of interesting as a society, whether indeed that's what we want to encourage. But so now that I heard your answer, I understand.
And Nathalie, I don't have any strong arguments against why not. I just contemplate scenarios like the following. So it's not uncommon that a law will be challenged on many different charter rights. And there are good reasons of judicial economy and restraint to try to settle a constitutional question on as narrow a ground as possible. And so you can imagine a scenario where a bill or an act is challenged on Section 2, 715, the court strikes down on 2, the legislature responds with Section 33 on 2, all right, and then it's challenged again in 7, and then so on and so forth. So it's questions of workability and whether the courts would want to entertain such back and forth, but there's no argument in principle against why it's not possible.
I gave you the thumbs up just kind of for fun there. I don't think that Section 33 should be used all the time. I think it should be used. I think judges make controversial decisions about the charter because it edges on the verge on what it verges on moral questions often that are not settled by the law of the charter, right? And especially the way the Oakes test is structured. And so 33 being used more often wouldn't necessarily be a bad thing. And when I talk about the potential politicization of our process over the long term, the long haul, it may be that uses of Section 30 be more frequent, but they're developing new norms for how to use it, may be better than the political process, than going on with the world where it's not used, and instead frustration about the courts takes the form of other forms of court curbing, right? So to me, what's really interesting about the recent uses is that they speak to a denial of or the eroding of what Professor Manfredi has called the older norm against its use, the developing norm. And what he did in some of his earlier work is model how, as we got farther away from a world where 33's use in, let's say, the Ford cases was on the horizon of courts, how courts became more aggressive, and things like the remedial activism became more radical. I started reading things into decisions, right? And so what's interesting now will be to see how its use at the provincial level, its more frequent usage, may actually then change and challenge and may change incentive structures of judicial behavior. And it may be that that has an effect that's more positive than, let's say, the American case, where the American notwithstanding clause is the appointments procedure, right? And when you say, why don't we amend the Constitution? Well, some of these moral questions are amending the Constitution. The Constitution is that they're changing in the sense that they're changing the Constitution's meaning, or at least determining it in ways that are highly controversial for subsets of the population, right? So anyway, that's my case against that.
Just very briefly, I'm intrigued by the varying views as to what the sort of impact of a judicial declaration about the effects on charter rights of a protected law would be. So for Jeff, it would be so drastic that it would lead to court packing and vicious attacks on judges on social media. Mary Eberts thinks it's so useless she couldn't ask her client to get it. So it's interesting to sense that. In terms of what the value of a charter process in front of a judge might be, you don't need to think that judges have a lock on the truth. But those processes do hear from some voices that don't get invited to the legislative hearings. So Quebec passes Bill 21, and they barely invited any religious groups to a very accelerated hearings process. And those people found their ways in front of Justice Blanchard. So you don't have to say that the judge is Hercules to say that there are voices in that process that we might not hear from otherwise.
Thank you very much. I guess I have two questions, mostly for Jeff, but I will follow up from Professor Webber, Dean Leckey. You spoke very passionately, Professor Sigalet, about you've used the institutional design problems with courts having this power and the negative consequences that would arise from issuing declarations in the face of Section 33. Maybe we agree with him, maybe we don't. But Grégoire has written in the past sharing many of your concerns, but he thinks that the text of Section 33 dictates a different result. And whatever we think about judicial power, they do have to implement the Constitution and the statutes. For instance, if Section 5, to use a clear example, is infringed, it's pretty obviously infringed. And you certainly have made a textual argument regarding Section 33, but I wonder if you would be on firmer ground if you tried to get many of your concerns into Section 24.1, where it talks about remedies that are appropriate and just in the circumstances, and making an argument that a declaration in the face of a procedurally valid use of the notwithstanding clause is not an appropriate and just remedy in those circumstances, and just generally where you have 24.1 fit into your analysis. And to your co-panelists, I'm curious the extent to which you thought, because I know Dean Leckey in particular has noted, there are times in which a declaration would be inappropriate, even if it could theoretically be granted. Do Professor Sigalet's concerns persuade you all about the propriety of giving such a declaration? So, thank you.
Well, that is an expectedly awesome question. So I just want to say that I may be exaggerating a little bit the extent to which there'll be like, the great flood if this happens. I just want to be the voice on the other side of the debate saying maybe there's maybe unintended consequences here, and I don't think that there'll be judges being called things on Twitter immediately or whatever. It just, if there's a norm that develops where courts stick their neck into this business, it could have adverse conflicts that way. But on your point, Gerard, sorry. My view about the subjunctive nature of 33.2 has the side effect of skirting the debate about and of explaining very succinctly why there's no Section 24 remedy in relationship to 33, because if the charter has if the law has the operation it would have, but for the provision, then the provision, in the sense that the provision is presumed to not exist for purposes of looking at the constitutionality of the law, then you cannot have a remedy in relationship to any inconsistency that might exist. It's just, you have to pretend that fish that's served to you is vegetarian, and there's no questions or remedies about the fact that it's a fish or that it's not vegetarian, right? Does that make some sense? And
no, it makes some sense. It's just like, would the better place be making this argument in 24 analysis than 33?
It could just go with it, right? Like, why not just say then, and that fits very nicely the language of 24 that says, and that would not be a just remedy to have, it would not be a just remedy in these circumstances, especially given the wording of 33.2. I maybe that's wrong. It also, but a similar kind of effect on my argument on 24 exists with 28 too. So Kerry Frox argued that the original meaning of Section 28 means that the Section 28 notwithstanding clause trumps the 33 notwithstanding clause, insofar as there's an interpretive requirement that sexual equality must be respected, notwithstanding anything in this charter, right? The sexual rights of the sexual equality of men and women, right? Male and female persons, I think is the wording, right? Well, those rights may be protected by the law, they may be violated by the law, and the law may be more or less consistent with those rights that are protected by that 28 notwithstanding clause, but it's not open to the court to look to how consistent they are, because those provisions, the provisions in which those other rights, the Section 15 equality rights provisions are not insofar as 15 is the target of a Section 33 law, are not on the table in terms of assessing their consistency with the law. Does that make sense? Okay, I'll leave it to somebody else to talk too much.
Robert, did you want to say?
You want to respond? I want to make sure that Xavier has a chance, if he wants, to weigh in on any of these questions. I'm sorry, I didn't intend to ignore you. So I wasn't looking at the screen, but if you did want to weigh in on anything that you've heard, please feel free to do so.
Okay, well, thank you. Yeah, I'll do one brief comment on the relationship between Section 1 and Section 33. And I'm not sure my co-author agrees with me on this, but the way I think these two provisions needs to be understood in a consistent manner is that Section 1 is a provision that allows or that kind of conduct or forms the judges and the courts in thinking about the scope of the rights themselves. And so if you understand Section 1 this way, when you conduct the Oakes test and you go through Section 1, what you're essentially doing is you're going through the criteria that allows you to specify the rights or the freedom that is being adjudicated. Whereas Section 33, I think, is of a complete different nature, because it doesn't frame the rights themselves. It suspends courts' opinion on those rights, and so it's not about how the rights are being determined, but it changes who determines the rights, and so there's a way to see Section 1 and Section 33 in a consistent manner, where really one is a mechanism transfer of jurisdiction. I think Sigalet also said that it transfers the jurisdiction of specification of right from the judiciary to the legislature, whereas Section 1 is really about the scope of the rights themselves, and it's a criteria checklist to help the judiciary in specifying and determining the right. And on this, I would say that I do agree that it would also, if you do allow courts to make declarations of violation, then of course it will lead to a more political court. And that is because courts and legislature do reasons about rights and freedom differently. Because courts are asked to adjudicate specific claims between two parties, and the reasons that the court must provide are very sophisticated. They have to hear lawyers' arguments, and they have to make a very a grand, consistent opinion about how this particular claim should be resolved. Whereas legislature reason about rights very differently. They think about general principles, and they take a broad range of interests into consideration, not just between two person in an adversarial matter. And so I do think that if you open the door for courts to do this latter type of reasoning and to reason about rights in a political manner, then yes, you'll definitely have a much more political court.
Respond more to the last round? Are there other questions or comments from anyone? So then I think we're, okay, great.
If we have time.
Sure, no.
I think kind of a recurring theme in today's discussions have been a distinction on the one hand between a reasonable disagreement on rights, on the meaning and the scope of rights, and then on the other hand, a kind of absolute violation or a derogation of rights. And so examples that come to mind from today for a reasonable disagreement would be, for example, Saskatchewan's religious education bill, and then maybe violations that come to mind would be Quebec's Bill 21, or as we heard, Ontario's Bill 307. So my question, maybe for all the panelists that wish to respond, is do you think that that is a reasonable, meaningful distinction? And then if so, is that a distinction available to the court? And then if so, how do we determine what is a reasonable disagreement and what is a complete disregard for maybe charter values? And then a second related question for Professors Webber and Leckey is, if we take seriously the role of Section 33 as a means for the legislature to define a right and have kind of good faith disagreements with the court, how much deference should the court give to legislatures in a review of a Section 33 declaration? Should it be greater than an ordinary Section 1 Oakes analysis, or is it, thumbs up, thumbs down, it violates or it doesn't?
Well, while these guys are collecting their thoughts, I can be very brief because my argument ends at the legal interpretive point. And so in my UTLJ article, I conclude by saying, although this is my best reading of what the clause allows for, I stay silent on whether a court should take up the jurisdiction or should decline to exercise it. And so that's another way of going back to the previous question. There are many reasons of the passive virtues not to take up the jurisdiction. There could be reasons to decline jurisdiction on a blanket basis or on a case-by-case basis, and I highlight those questions, but duck out of the really hard task of answering any one of them.
Grégoire's response to that, it reminds me of the anti-federalist Brutus. One of the opponents of the ratification of the Constitution. He's upset by me on comparison, who continually in all of his letters and missives writes, "Well, I'm just a country lawyer. This is not really my field of expertise," and then like subsequently launches into like an exact, precise dicing of the nature of the legal question at stake in the Federalist, and it has a clear like political motivation. And I really wish we could get Grégoire to budge on that and tell us more about what he thinks morally about some of these things, but we can't. So on the question of reasonable versus unreasonable rights, I have said that. I've tried to say, well, what I think as a citizen, reasonable disagreements about rights, right? So what I've tried to say is I guess maybe it's come off that I've said that there's a reasonable disagreement to be had about religious freedom in the case of funding denominational students at non-denominational students at denominational schools in the Saskatchewan schools case. And maybe it sounds like I've said that's a reasonable disagreement, and an unreasonable disagreement is those who support laïcité and say that's not a violation of religious freedom to prevent citizens of the Quebec state or public servants of the Quebec state from wearing religious symbols. I wouldn't even say that. I would say that that on the one hand, there is a view. It is a view of religious freedom to say that the state should be neutral this way, in the sense that no servants of the state should wear religious garb or religious symbols of any kind. That is a view. It's just not a view consistent with the Canadian tradition of an understanding of religious freedom, which involves a significant element of the free exercise of religion as being part of what it means to be to have freedom of religion, right? But it's not that a citizen who thinks the other way is unreasonable, and it's potentially detrimental to the discourse to continue to insist that it's just discriminatory. And in particular, it seems wrong to me to mischaracterize a rights disagreement that way between a good faith person who says, I believe in laïcité, that's my conception of religious freedom, and someone who says no, religious freedom involves free exercise, and characterizing that debate as really being about race or something like that. It just seems to be, to me to be potentially obfuscating the issue there. But in any case, what I really want to say is my overall meta comment about that is that my general comment on reasonable versus unreasonable is it depends on where you stand, where you sit, and the law settles and sets demarcations of what might be reasonable or unreasonable in relationship to our past decisions about what we count as reasonable or unreasonable. And so it guides us that way as a kind of compass. And the Charter is part of that. The Charter is a step, and the 2A protection of religious freedom is a step in the development of the Canadian conception of religious freedom, from the implicit rights jurisprudence that we had before, from the protections we had for minority denominational schools in the trunk of the 1867 British North America Act. But when it comes to just strictly just abstractly morally, one person's reasonable disagreement is another person's unreasonable disagreement, and we have a danger thinking that what we think of as an unreasonable disagreement is really someone else's reasonable disagreement, and democratically disrespecting our fellow citizens' ability to have a say about where those lines should be drawn. And a lot of lawyers think that they have somehow some magic wand they can wave where they get to set the lines of that debate. And what's odd is that often their views of where the reasonable disagreement ends and where it begins have nothing to do with the law. But you already knew I thought that, so I shouldn't.
Okay, very briefly, I don't think it's very helpful to speak about individuals' views as being reasonable or unreasonable, and I don't think that that's what I was sort of hearing in the course of the day. What I was thinking about more was that there are contexts where elected lawmakers really appear to be engaging with a conception of rights, and other contexts where they seem to be using Section 33 and saying, like, we're actually not into this whole rights project at all. So, I mean, contexts where you sort of say, look, the majority wants this, we don't care about minorities, or we're going to invoke closure in the legislature because we don't want to hear opposing views, or we're not going to invite people who might oppose the bill to come and speak to us, and the majority wants this. That doesn't speak to me about a reasonable or unreasonable view on the substance. That's just a kind of lack of interest in hearing a range of perspectives, sort of saying litigation gets in our way. Again, that's a lack of interest in having checks and balances. That to me is quite distinct from saying a particular view on one right or another is reasonable or unreasonable. So I think, to me, when we've seen the range of attitudes towards fundamental rights, I don't think it's a thing for the judges, but for the people who look at Section 33 to say some of the sort of cases that make it look the best suppose that legislatures are really engaging in debates about rights, but that's actually not what we see in at least some instances. In terms of the deference, I think if the government, made a case even in the legislative process showing it had considered the trade-offs and the negative impact of the law that it was about to protect with Section 33, I think courts would put a lot of deference towards that. They would normally do that under Section 1. I think they might well do that under Section 33. But we have seen some uses of Section 33 where it really doesn't seem like the government has any kind of evidence or that has been looking at the impact of the law. And so that's the kind of stuff that's, I think, quite significant in the discussions today.
Thank you very, very much. Well, we're going to have fun tomorrow when Svi Kahana doesn't talk about reasonable versus unreasonable, but rather tyrannical versus that which doesn't rise to the level of tyranny. I can't wait for that discussion. And we'll see whether there's some objective standard there or whether we're just into your morally relativistic universe, Jeff. I want to thank all the panelists today, and I want to thank all of you today for your attention and your attendance. I hope you've enjoyed the day. I know Natalie hopes you've enjoyed the day. We're delighted to have had this day, and we're looking forward to seeing you, hopefully all of you, bright and early tomorrow morning at 9 o'clock. Is that right? Yeah, 9 o'clock we start tomorrow. And I think there's a reception in the common room now for an hour until 5 o'clock. So thank you so much, and thank you to our panelists and the speakers.